to Sakshi TV's special immigration show with attorney Bhanu Babu Illindra from BBI Law Group. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Illindra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice. Use of content is for general informational purposes only. Sakshi TV or its agents in the USA or our guests on this show are not responsible for use of information as a legal advice. If you need specific legal advice, please contact the attorneys directly. We will be also taking any general immigration questions along with today's topic. Hello Bhanu Garu, welcome to the show.
Thank you, Attorney Garu. How are you?
Very well.
Thank you very much for inviting me to the show.
Same. I hope you're doing well too, sir. So could you please provide information on your law offices, practice areas and experience, please?
Sure, Attorney Garu. Thank you very much for asking me that. My name is Bhanu Illindra. I'm an immigration attorney. I've been practicing immigration law for almost 18 years in the US now. And I started my own firm in 2008. It's called BBI Law Group PC. My firm is located in London, Virginia, which is Washington, D.C. suburbs. We exclusively practice in immigration law, all types of immigration matters like employment-based immigration, family-based immigration, immigration litigation, EB-5 investor visas, F1, J1, whatnot. A to Z immigration matters we represent before the USCIS and various other agencies. Any further details about my firm, please visit our website, www.bbilawgroup.com. My office number is 703-496-7722. Email is bhanu@bbilawgroup.com. You can also reach us through crm@bbilawgroup.com. Any questions you have about immigration law, feel free to reach us. We're very happy to help you all. Thank you.
Right. So Bhanu Garu, before we go into the topic, we already have a caller, Amit from San Diego. Thank you for calling, Amit. You may ask Mr. Bhanu your question directly.
Yeah, thanks. Hey Bhanu, this is Amit. Hey Bhanu, can you hear me?
I can hear you, Amit. Yeah.
Okay, perfect. Hi, good afternoon. Hi, my question is actually, so I'm on H1 and I did my first 140 got approved in 2010. So my priority date is 2010. And then it never been current. Then I changed my job in 2018 and they filed a new I-140. And then now 485 they file in this May 2021, May 10th. So it has been like 180 days past now. So if I change the job or if I get laid off, then what's my situation? I have to file new H1, but is the what about I-485?
Is your I-140 approved? The second one filed by the new employer?
Yes. Yes.
Yeah. If the I-140 is approved and it's been 180 days since you filed your 485, then I don't see any issue for you to port your green card to any other employer in the same or similar occupation. Okay? So there is a very little of concern for your 485. If it comes to H1B extension, because your I-140 is approved, if your priority date is current, then you may not be eligible for the H1B transfer or extension basically.
But then how can I change my job then?
Based upon the EAD. If you have an employment authorization document pursuant to file your 485, you should be able to join the new employer based upon that EAD. Because the regulations under Section AC21 Act 104C requires the I-140 must be up. There are 2 aspects through which you can get your H1B extension beyond usual 6 years. Okay? There are 2 sections. One is Section 106A and B of AC21 Act. Other one is Section 104C of AC21 Act. As per Section 106A and B of the AC21 Act, it says that if your ETA 9089 labor certification or your I-140 is pending at least for 365 days for adjudication, then one is eligible to seek an H-1B extension for 1 year duration beyond usual 6 years. That in general terms, we call 7th year extension, basically. Okay? And the second section, which governs somebody to get an H-1B extension beyond usual 6 years, is the AC 21 Act Section 104C. What that requires is that once immigrant visa petition must be approved and their immigrant visa numbers are not available as per country limitations. That means the final action dates must not be current for that individual at the time they're actually seeking H-1B extension beyond usual 6 years for one-time 3-year period at the time of filing that H-1B extension, or from the date that extension has been sought. Okay? In your situation, unfortunately, I'm assuming you said in 2010, and EB2 preference category or EB3 preference category for 2010 or final action dates are current right now. Therefore, you may not be eligible to seek the H-1B extension beyond 6 years period. Although you can, that's the problem. That's why when you're filing for a transfer, you're not only transferring your H-1B, but you're also seeking an extension of status for you to continue to work with that employer based upon that H-1B filing. That is why you may not be eligible to seek extension because your I-140 is already approved, and I'm assuming that your priority dates are correct. The only option is for you to transfer to a new employer is right now is based upon your employment authorization document approval in conjunction with filing of your I-485 application for adjusted status as a permanent resident.
Right. I hope that answered your question, Amit. So, Bhanugaru, we have another caller on hold. Ms. Sudha Rani from Maryland. Thank you for calling, Sudha. You may ask Mr. Bhanu your question directly.
Hi, Bhanu. Good evening.
Good evening, Ms. Sudha. How can I help you?
Yeah. I have a question regarding a new policy change that happened recently on November 10th related to H4 EAD auto extension. Right? So, I am in a situation where I have applied both H1, H4 and H4 EAD together. Both my H1 and H4 are approved already. So only H4 EAD is pending now. So am I beneficiary for that change that happened? So can I start resuming my work again with the auto extension policy?
There are different aspects in this situation. You have to understand this. I think I have to explain in clarity who may be eligible for automatic extension pursuant to their H4 EAD renewal application being filed. In your situation, when you file your H4 EAD renewal, do you have a valid H4 status at the time or not? Is not clear to me. Okay.
Yes, I had H1 valid status.
And was it expired in between any time? Or did you get an approval
No, it did not
prior to the
expire.
expiration of that?
So
your
H4
H4 has been approved. Your H4 extension has been approved prior to the expiration of your H4 status. That's what you are saying.
No, after expiration of my H4, I applied already, so it got approved after the previous H4 got expired.
Okay. If that is the case, with my understanding of this particular settlement and the policy guidance issued by the USCIS today, is that probably you may not be eligible for the automatic extension. Okay? Reason is, what USCIS said that is, if on the settlement agreement which they had with the American Immigration Lawyers Association and their partners who fought this lawsuit with the USCIS, and the policy guidance, actually today, in fact, in the evening, USCIS did issue a policy guidance on how they're going to implement the policy pertaining to the settlement which they had with this particular case, in this particular case. As per them, what the USCIS said that is, at the time you file your H4 EAD renewal and the date your EAD renewal expires, you must have a valid I-94 pertaining to that. And there are three things can happen at the time. Your automatic extension beyond your H4 EAD renewal authorizes you to work in this country or occurs to you is if you have a valid H4 status at the time of your H4 EAD expires and you file renewal timely prior to the expiration of that EAD. And also the requirement is that whichever is earlier of. What does it mean is that if your H4 extension, when you file for H4 EAD renewal, the automatic extension, upon expiration of your H4 EAD, the automatic extension goes to till the date your I-94 is valid, whichever is earlier of, your I-94 is valid, or till the date your H4 EAD renewal application is adjudicated or denied, or till the date to the maximum amount of 180 days. So whichever is earlier of that. So in your situation, what you're telling me is that you file for an H4 EAD renewal and H4 renewal also at the same time, and your H4 status is expired while your renewal application is pending. Therefore, your automatic authorization ends on that day. But the new H4, when you file for an H4 extension, that H4 extension has been approved, but EAD is not approved. But you do not have an automatic work authorization right now. Until the EAD is approved, you cannot continue to work because of that situation, because of the gap in your H4 status.
Right, I hope that answered your question, Sudha. So, Bhanu Garu, we have Amit on the call again. He wants to ask you one more question. So, hi Amit, welcome back. You may ask Mr. Bhanu your question directly.
Yeah, thank you. Hey, Bhanu, so I was saying that my 140 is approved and then my EAD hasn't come yet, okay? And they have filed 1 year extension last May, so it is valid till May 2022, okay? So what? So I cannot leave the job right now, that's what you're saying, till my EAD comes in?
You can leave the job if you want to leave the job, but you cannot work without proper employment authorization. So that's all I can say.
You cannot
It's
do
not
the
a good
H1?
idea to leave the job. Yeah, it's not because you cannot file an H1B transfer, because H1B transfer requires you filing an extension, and the extension, you're not eligible for the extension anymore because your priority date is correct. Okay?
Okay, so H1 is out of picture.
My advice will be is that you need to wait until your EAD is approved so that you can transfer to a new employer.
Okay, so perfect. And then that EAD, I heard that after EAD comes in, you have to wait for 6 months?
No, not really. The requirement is you have to, your 485 must be pending at least for 180 days from the date your 485 has been filed. That's all is required to port your 485, your green card, your I-140 to a different employer. Provided your I-140 is approvable at the time of filing I-140, and the best scenario is it's already approved. In your situation, it's already approved. The new I-140 filed by a new employer is already approved. Therefore, it is easy for you to port your green card without any problem, provided you have a proper work authorization. Until then, don't port. Don't leave the employment.
Okay. So I have to wait for EAD. Okay. So my 185 and my 140 and 485 was filed simultaneously and approved like in couple days. 140 was approved in couple days, and then this has been 6 months now. But you are saying I have to wait till my EAD comes in. Okay.
I'm not telling that you have to wait till your EAD comes in. What I'm telling you is that you can port your green card without EAD also to a different employer. You cannot work for another employer without an EAD. That's what I'm saying. There are two different things. Porting your green card is a different thing, and you working to another employer is a different thing.
Right, I hope that answered your question, Amit. Thank you for calling. So before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. So Bhanu Garu, do we have any updates on immigration this week?
Actually, we did touch the topic today a little bit about the H4 EAD extensions, about the policy guidance. that has been issued by the US is pertaining to the lawsuit settlement they had with the American Immigration Law Association on November 10, 2021. But it's important for me to discuss in detail about the settlement and the policy guidance issued by the USCIS today, so that people will have an understanding under what circumstances they can take advantage of or continue to have an employment authorization under the circumstances. Today, the policy guidance issued by the USCIS clearly addresses situations where people will have automatic EAD extensions or automatic employment authorization in this country while they are in H4 status, L2 status, and E2 status, basically. Okay? It's important that who are these? H4s are H1B dependents, L2s are L1 dependents, E2s are basically E3 dependents, basically. E dependents, basically. I'm not talking about E2. I'm talking about E dependents. I'm sorry, I used word E2, it's wrong. I'm talking about E dependents, basically, right? E dependents. These are the individuals will have an automatic work authorization if they meet certain requirements. First thing is very important is about the H4s, because there are many people are really eager to understand what this particular settlement means to them, especially for the ones whose H4 applications are pending. H4 EAD renewal applications are pending, and their existing EAD is expired and they do not have any work authorization. Not everyone benefits, not every H4 who is under the situation benefits with the settlement. Only certain few, select few will benefit with the settlement. Who are those? What is that select few? This thing is, what they said is that one should have a valid employment authorization document at the time they're filing for H4 renewal, H4 EAD renewal, and also should have a valid H4 status continue to exist at the time their H4 EAD expires. Okay, there are two aspects. One is one should timely file for H4 EAD renewal prior to the expiration of their existing H4 EAD, and at the time of expiring that H4 EAD, one should have a continued validity of H4 status. Okay, and if they meet these two requirements, then employment authorization for that particular individual who has an H4 EAD automatically extends to the duration which is earlier of one till the date the I-94, that means the form arrival departure record, which actually determines the status of the individual whether he's an valid H4 or not, till the validity of that I-94 date, or till the date of the adjudication of the H4 EAD renewal application, whether it's approval or denial, whatever the adjudication is, or up to 180 days at the maximum. So whichever is earlier of, they will get automatic employment authorization. So right now, until today, H4 EADs, if the EAD is expired, they cannot work. But with this particular settlement, with this policy guidance, they will be able to work till the date, even though the H4 EADs are expired. If they file timely H4 EAD renewal, they will be able to work till the date their I-94 is valid. That means till the date they have a valid H4 status, or till the date their H4 EAD renewal is pending or adjudicated, or till the date their are to the maximum extent of 180 days, basically. So whichever is earlier. That is one aspect of Garu. Okay. Second aspect is E status, E dependents and L dependents, that is L2s and E's, E dependents, they get automatic work authorization incident to their status in the US. That means if somebody enters into this country as an L dependent or a E dependent, they have automatic work authorization. They do not have to apply for employment authorization document. They can automatically work based upon that. They can apply for Social Security, they can apply for the jobs, and they can start working with the jobs. And the way they provide the employment authorization is by showing their E status, I-94 issued with the E or L status as a list to see document along with the list to be document for the I-9 verification purposes. That's how they can do that.
Right.
Okay, so E and L, they do not have to apply for separate employment authorization as per this policy guidance. That's a very good news for L's and E's.
Right.
Okay, however, there is one caveat there. If they don't apply for employment authorization, then if the L status expires or E status expires, and if those are pending for renewal, during the pending period, they cannot work. Their employment authorization automatically expires on the day their status expires. That is only the caveat there, but it's a good thing. This is what the law is supposed to be, and now USS got it correct. Now L2s and E's, E dependents, they can actually go ahead and just start working in this country once they enter into this country on those visas. That's a very good news for me.
Right.
So this is the policy guidance. It's very important to understand this policy guidance. You know?
Right. So, Bhanu garu, sorry to cut you in between, but we have a caller on hold. Sudha Rani from Maryland again. Thank you for calling again. Sudha, you may ask Bhanu garu your question.
Yeah, hi Bhanu garu. Sorry, I just want to check with giving my date to you. Like, you know, my first H1 got expired on August 31st, 2021. And my next H1 got approved on October 5th. But on the new H4 I received, I have it starting from September 1st. So, is that not still a valid case for that scenario, like EAD extension?
Yeah, still, you have to wait until your EAD renewal application is approved to work. The reason is here, it is dependent upon your H4 status, not H1B status here. Okay, and when you apply for H4 renewal and H4 EAD renewal, while EAD renewal is pending, your H4 status is expired, and also your H4 EAD also expired. That is the problem here. Okay, and then later on your H4 renewal has been approved, but your EAD has not been approved. Because H4 renewal has been approved, it does not automatically authorize you to work from the day it's been approved. You know, that's not what this policy is all about. This policy says that one will be able to work, or their employment authorization automatically extends only when their H4 is valid at the time their EAD expires. And that validity continues for them for a certain period of time, or the maximum of 180 days authorization will be given to them until their EAD is valid, whichever is valid. You know?
Okay. Got it. Thank you, Bhanu.
Right. Thank you for calling, Sudha. So, Bhanu garu, we have another caller on hold, Miss Vani from Chicago. Thank you for calling, Vani. You may ask Mr. Bhanu your question directly.
Hey, hi, Bhanu. I have a couple of questions for you.
Sure, Vani, please go ahead.
Actually, me and my husband have applied for I-765, EAD, and I-485 on August 12, 2021.
Okay.
Hello, are you able to hear me?
I'm able to hear you. Okay, I just lost a little. What you said? Your husband and you applied for EAD.
We have applied for our EAD, I-485 and I-131 on August 12th, 2021. My husband's EAD and advanced payroll has been approved, and my EAD has been approved, but my I-131 has been denied, stating that I have entered the country on so-and-so date. You may be inadmissible for procuring immigration benefits by fraud and misinterpretation. That was the denial notice.
Ma'am, I'm not able to really understand what the reason. I mean, I think this information is very sensitive in nature, which I need to discuss with you. I think it's a good idea you reach out to our office, set up a time, and discuss in detail, because you're saying that they're claiming that there was a fraud or misinterpretation on your behalf while you entered into this country. That's why they denied your I-131 advance payroll. I mean,
but
there could be some error. I'm not able to hear you clearly, madam. And there could be error, or I need to know the facts more in detail, exactly what happened with your situation, with your facts, with your prior stays and everything. So I would appreciate you talking privately with me, Ms. Vani. And you can reach my office, set up a time. I'm available during businesses anytime. And I'm very happy to talk with you and see how I can assist you with this and go through this proper. Okay?
Right. So thank you for calling, Vani. And getting back to the topic, Bhanukaro, is there any other updates that you'd like to give us?
That's all. I mean, as I said today, the most important update is this. This is a very good one. It's a good news for L2s and Es. It's a great news for them, and it is good news to certain H4 EAD individuals also, basically. So one way, it's a very positive change from the USCIS. At least now they're adhering to the law rather than making their own interpretations, which are very conservative in nature or which is very restrictive in nature. So that's a very good thing. Now, thousands of people, again, will be able to get back to their jobs, able to continue work and everything. And that's a very important, that's a great development from the USCIS side this week. And other important update is that the USCIS, DHS issued a policy guidance also about the travel ban lifting because of the COVID-19 pandemic from various countries to travel to the US. Now, the travel ban has been lifted, which is effective from November 8th, 2021 onwards. Now, people who are fully vaccinated should be able to come to this country without any problem if they provide the proof of their fully vaccination record and as well as the proof that they have been tested negative within 72 hours prior to the departure to the United States. And also Department of State also, CDC and Department of State also has been provided guidance on this. And Department of State clearly said that whoever is applying for the visas at the consulates, they should provide the proof that they're fully vaccinated, And one more good news for the Indian nationals is until the last week, we were worried that only the individuals who are with Covishield can come into this country because only Covishield was authorized by the WHO or recognized by WHO as a valid COVID-19 vaccine. But now they have also approved the emergency authorization for the usage of Covaxin also for the COVID-19 vaccination. So that is also very good news. So people who are fully vaccinated with the Covaxin or a Covishield from India now should be able to travel to the US without any problem. The requirement is that they provide the valid proof that they're fully vaccinated to the Department of State when they're applying for the visa, so they should not have any problem getting visa stamped and able to come into this country. So these are the two important updates I would like to provide today, Torni Garu. Not more than that.
Right.
We'll have something else to talk next week.
Right. Thank you, Mr. Bhanu. So with that we come towards the end of the show. So before we close, is there any golden immigration message that you'd like to give our viewers?
As I said, be positive. I think now we have we have a system where we know that USCIS is backing off when we are filing lawsuits against them, litigations against them. So my advice is always have your American dream alive, keep alive. Still, America is the land of opportunity. And if you are qualified enough, if you are talented enough, I think you should still pursue your American dream. Never lose hope. That's all my advice is.
So for everybody watching our show, Bhanu sir's last words, for the show is about pursuing the American dream. And with that, we end the show. Thank you for being on the show, Bhanu Garu. It's a privilege to host you like always.
Same here, Pratik. It's a privilege for me to participate in this program. And I really thank you, Sakshi team. Every one of you do an amazing job every day. Every time I see how the shows are conducted with Sakshi TV, Thank you.
Yes,
thank you
sir.
very much.
Have a good day, sir. You're watching Sakshi TV Live with me, Torini Makana. Thank you.